respected panelists, my dear colleagues, and dear participants. Today we will have the last session for Mr. Banerjee. So whatever questions that you will have in your mind, please share with us. If some questions remain unanswered, definitely we will try to solve those questions and put it in the chat box, your question, all the questions. It might happen due to shortage of time, we won't be able to address all the questions, but definitely our panelists are trying their level best to answer all the questions. Wish you have a very great learning session. Over to Mr. Banerjee. Mr. Banerjee, please.
Thank you, ma'am. Am I audible?
Yeah, sure, sir.
Okay, great. Okay, this is basically season 1, episode 3 for all of you, and this would be the season finale, at least from my side. The topics would keep on continuing after this, and we have very interesting topics after today. Please stay tuned for those sessions too. For today, actually, today would be my last session with all of you guys for time being. So let us start. Before starting, today's session, I would keep it short, and I would open the floor for questions. So feel free to ask questions from any of the sessions that I have taken or Pinakida has taken before us. So maybe last three sessions, whatever we had. Introduction to IP, basics of patent, and advanced patent session. So any questions you have, please feel free to ask questions on that in today's question and answer session. So today we would be delving into a very, very, very interesting topic. It's artificial intelligence and IP protection. So you would be seeing this term artificial intelligence almost in in any tech blog or anywhere you read, and even in blogs and even in Facebook, everywhere you see AI. And AI is a buzzword. Previously, it was big data, and then there was robotics and all those terms, and now it's artificial intelligence. So this is not a new concept. Okay, thank you. Yeah. Today we will be discussing about artificial intelligence. So basic topics that we would be covering today are. Yeah. So we would be talking definition of artificial intelligence, evolution of artificial intelligence, how it's evolving in the world. And the AI and patent proliferation, how much patent and what is the role of patent in AI proliferation, how companies are proceeding with AI protection through patents. What are the issues in the present IP regime, and what are the things that we all need to think through, because the policy and the law are yet to catch up on this domain. And then we would discuss on a problem solution approach, how to solve those problems. So this would be more of a non-technical session, because there would be many people over there who have very in-depth knowledge about artificial intelligence. I would be restricting today's session only for the legal part of it, and have a very basic introduction to AI before the session starts. So let us understand the definition of AI. So this term was coined in 1955 by Professor John McCarthy of Stanford University. World Intellectual Property Organization has defined AI. So there are multiple definitions of AI. So one of the very relevant definition is it's obviously a discipline of computer science, and it is aimed at developing machines and systems, and of course software, that can carry out tasks which otherwise would have required human intelligence. So to some extent, substituting human intervention through machine, and machine taking its own decision, machine showing its own intelligence. So that is one of the definitions. So machine learning and deep learning are the two subsets of AI, two major subsets. In recent times, we have started having various types of neural network techniques, and we are also evolving the hardware ecosystem around artificial intelligence to ensure that AI works properly. So the WIPO definition specifically states that the synonym for AI is deep supervised machine learning. So in a nutshell, we can say that it's a machine which can, to some extent, think like that of human, take decisions autonomously, perform tasks which would otherwise would have required human intervention. So that is what the basic definition of AI is all about. So the evolution of AI, how the technology around AI is evolving, and what is the goal, or where do we want to end up. So but we all see those movies like Matrix, like Terminator, and all those sci-fi movies wherein machine takes over the world. So are we at that stage, or at what stage that might happen? So, right now what we see around ourselves is more or less artificial narrow intelligence. So it's something like, the narrow intelligence of the machine is of such nature that it can perform tasks or take decisions in a particular domain or in a particular type of task. So Deep Blue, or other chess playing AIs, can defeat the world chess champion. So it can defeat Kasparov, but it cannot figure out how to drive an autonomous car. So if I want to develop a driverless car, this artificial intelligence cannot help me. So this is a very area specific, domain specific AI. That is why we call it a narrow intelligence. So human beings have developed narrow intelligence long back, not long back, maybe 10 or 15 years ago already we have developed it. So now we are slowly and steadily, we have started our journey to reach towards artificial general intelligence, but it's still some road that's left in front of us to achieve AGI. So what is AGI? So AGI says it's a general mental capability, okay, that involves the ability to reason, plan, solve problems, think abstract, comprehend complex ideas, learn quickly, and learn from experience. So this is what basically makes a machine, think like that of a human being, or learn like that of a human being. So this artificial general intelligence would enable machines to some extent, absolutely, I would say, you know, uh, replace human beings in some of the day-to-day tasks, which are low skilled, which does not require too much of thinking, which does not require too much of intelligence. So such things can be done by a AGI, and it can have multiple domain, I would say, percolation. So it can percolate to multiple domains. So the same AI which can, basically run a robot, can also, run a, I would say, maybe a, a car, or maybe it can fly a airplane. So that kind of AGI is not, I would say, is not too far away from us. So maybe we would be reaching it very soon. The last stage comes, which is what we have seen in movies like Matrix and other sci-fi movies. So over there, we talk about a machine which can basically is smarter than human beings. It can think, it can comprehend, it can create in practically every field, and it can beat human beings in practically every field. It would also have social skills. Maybe tomorrow it may have emotions. So we do not know about that. So those are the things like it's far-fetched. Human beings are, as of now, no way near to ASI, because we lack that amount of computing power. But the way the computing power is increasing over the years, ASI may not be a very distant proposition. But yes, technology as of now is nowhere near to it. And this ASI is the domain, or is the time when the problems start. No, I'm not talking about those sci-fi movie problems. I'm talking about problems when they start inventing, they start creating IP, and they start solving problems, then who owns the IP in that? So how to devolve the IP ownership in such machine created inventions? So that is one of the key propositions, some of the things that we would discuss today. Okay. So let us understand like how much importance does patents have in this artificial intelligence domain. So if you look into this curve, various countries like United States and specifically now China, they're filing huge number of patents each year. So if you see the curve, all of the curves are almost exponential, and post 2011 they are rising very steeply, very drastically. And very interesting, China is emerging to be one of the leaders in AI driven technology. So if we have to replace China in the global market, India that we are thinking about, so in all the social media in these days, we have to innovate like them. Otherwise, merely speaking, India replacing China would never happen. So innovation, the key lies in innovation, the key lies in human brains. Okay. Now, if you see the patent families and number of patents owned by various companies, it's IBM, of course, is leading. We have Microsoft Corporation, and it's very interesting to see so many different Chinese organizations, and most importantly relevant for techno group of academics or techno group of institutions is that so many Chinese universities are filing so many patents in the domain of AI. So in future we see that academics and universities will be driving innovation, because China is showing the road, and of course US, many of the US universities files lots and lots of patents. So something that techno should think about in long future. So as of now, what we see that various companies across the world, almost all major companies who are in technology domain are, I would say, branching out to AI, application of AI in their particular domain. So if it is a pharmaceutical company, they are investing in AI for drug testing, or new molecule formulation creations, or maybe how to manufacture it more efficiently. So AI is over there. If you think about softwares and software industries, we are investing hugely in AI to ensure seamless customer delivery, to understand customer requirements, to predict and prescribe for the future requirements of the customer. So all those things we are investing hugely. Not only that, if you now think about mechanical engineering and robotics and similar domain, so all of them are investing hugely in AI, be it automobile sector, be it industrial manufacturing, even civil engineering, all those domains, and they are investing in AI to make human lives easier in their particular technology or in their particular domain. Now, let us, before going into the problems, like what are the problems in IP protection for AI, let us understand how do we at all protect the IP in an AI that we have created. So most importantly, the AI proliferation or AI future innovations of AI lies in very strong mathematical models. And yesterday and day before yesterday that we talked about, we stated that pure softwares, algorithms, mathematical models are not patentable. So that is one of the key challenges. So if you are trying to patent AI technologies, you have to be very, 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 clear and very concise, and you have to narrow down your inventions so that you do not end up claiming a algorithm. You do not end up claiming a mathematical model. So system implementation is required for AI patent applications. So you have to show specific distributed systems around the AI to ensure that your AI is bound to a particular technology domain or particular use case. So without that, it might fall. The patent application might be rejected. So it's always advisable to narrow the claims to specific technology and business domain. That's what I was talking about. Next issue is open source. So as you understand, proliferation of AI and the future of AI lies in the usage of havoc usage of open source. Open source basically enables free flow of technology across various communities, across various coder communities of the world, and a very strong and I would say crystal clear open source mechanism or open source governance mechanism would ensure that this open source softwares are rapidly used or drastically used in all AI implementations. That would basically save a huge amount of time for we have a misconception that open source means it's a free software. We can use it as and when in whatever way we like it. It's not like that. So open source is not free software. So maybe we can have another session on open source itself, because it's itself a very huge topic. Mm. So let us understand in this way that open source is not free. Mm. What is important for us to understand is always get in touch with the IP attorney to understand that what are the implications of using open source. So it might happen if you use certain types of open source in your code or in your product that you are developing, it may end up contaminating your code, making your code open source, and then you might be forced to reveal your source code to the end users, or maybe you have to give it to the open source community. So that is something very risky for product developers. So whenever usage of open source has to happen in any product development, consulting an IP attorney is very important. Next requirement is for copyright registrations of source code for artificial intelligence domain specifically. So under the copyright law of US and also in India and other parts of the world, you have to submit 50 pages of the code for getting a copyright registration of it. You do not need to submit the full code. You have to submit 50 pages. First 25, last 25, they say, or the most or the best representative 50 pages of your product, software product. So you have to very seriously and very selectively choose those 50 pages to ensure that your product is properly represented in that particular copyright application. So that is another thing that IP attorneys would help you in do it. Then most important part again is third-party components. So without third-party components, it's not possible today to develop any product from scratch. It's not possible basically. So whenever you are developing something on top of Java platform or .NET platform, you have to take license for those base platforms to develop something on top of it. So whenever you are using a particular type of database, you have to take a license for it. Whenever you are using a particular type of interface or a middleware, you have to take license for it. And all of those licenses come together makes it's just like a soup or a broth with so many different kinds of substances in it, and they might interact with each other in very different ways. So why this is very relevant for AI? Because AI requires so many different interdisciplinary types of softwares coming together. There might be a huge issue in this license compatibility, in these licenses, how they interact with each other, these third-party licenses. So this is another thing that IP attorneys are working in these days. So that's why IP attorneys needs to be consulted for developing new products in AI domain. Okay, now we come to the most interesting part. So this is something would be a food for thought for all of us. Just one second. Okay. So now just let us think in this line. Whenever someone files a patent, there's one inventor, as I told yesterday. So inventors are human beings. So under present law, only natural human beings can be inventors. And suppose I work for Cognizant. So I invent something and Cognizant becomes the assignee or the owner of it. So that is how innovations has been happening throughout the world till present time. So human inventor, then the final owner of the patent can be a human or can be a company or any other legal entity. Now things start changing, and the issues keep on cropping when machines start inventing. So what happens when a human being, with the help of a machine, AI machine, invents something? Then who is the inventor? Should I mention the human being as the inventor, Should I also include the machine as an inventor? That is a major question, because going ahead, without AI machine help, many of the inventions would not happen. And it's not mere tools that we are talking about. So those AI platforms or AI systems would not be mere tools. They would be co-innovators. They would be contributing hugely to the innovative concept. So it's not like I have to invent something and I use a machine or a a robot for helping me inventing. It's not like that. So that person or that particular machine would be equally contributing to this particular inventive concept. So who should be mentioned as the inventor? Next is, what happens when a machine alone, without any human intervention whatsoever, invents a new patent or invents a new patentable concept? Then what happens? Who should be named as the inventor? And then who should be the owner of such patent? Because a machine uh, might not have a owner always, because in the world of open source, in the world of free technology, there would be autonomous machines which basically runs or operates as bots in internet, and they would remain alive. They would keep on inventing without any human ownership or without any human intervention. So what happens in such scenario? So in a very recent case in Europe and US, what happened was a person had developed an AI system. The AI system invented, I think, a safe can, okay, a can for storing food or something like that, and it's very safe. And the machine invented it, and the patent was filed as the machine as the inventor. European Union EU patent system rejected it, saying that a machine cannot be the owner. So it has to be filed in the name of the person who has invented that AI system. Now, that person who has invented that AI system, the CEO of that company, very reluctantly stated that I know nothing about cans or food cans or safety cans. I know nothing about them. I know how to develop a software to make a very good AI system, but I know nothing about software cans. So how can I be the owner, inventor of such a patent? So that would be absolutely a lie to the world. So those are the concerns, and those concerns are not yet addressed by today's laws. And recently, the same case was in US, and US also rejected it, saying that no, only human beings as of now, can file patents, not machines. So basically, this is a strategy wherein you keep on, burying the non-performing assets of a bank and think that they would become okay later. That's not going to happen. So you have to have a policy to resolve the issue. Okay. So then once machines start inventing autonomously without any human intervention or without any human ownership, then who becomes the owner of such patent? So a machine cannot file a patent as of now on its own. In future it might be, because almost now, at present, you do not require any paperwork to file a patent. You can file it absolutely online. So tomorrow, if the portals are open, and if machines are allowed, they may file their own patents. So who will be owner of such patent? Because machines tomorrow might have their own money. They may have bitcoins. So they, by doing innovations, by doing mining, machines can also earn bitcoin, and through those bitcoin they can pay the fees for filing a patent. So who would be the owner of such patent? So this is something that is very intriguing, and no answer as of today. Next, the problem start with person having ordinary skill in art. So yesterday, when we talked about obviousness, we said that rubber, that eraser, and that pencil story. So eraser and the pencil and rubber band, makes a new device, but it's obvious to a person having ordinary skill in the art. Posita, that is a very important concept in US law and also in India and elsewhere in the world. Person having ordinary skill in the art. Now just think in a scenario where a human being files a patent. Who who should be a fauceter for that? Can a machine be a fauceter for a human patent? Because going ahead, machines would be way smarter, way more resourceful. They would be processing thousands and thousands terabyte of data in seconds. Uh, so if we compare human mind with machines in those days, it might be uneven war. It might be a uneven competition, and human beings might fail in certain circumstances. They might win because of their creativity, but in certain circumstances they may fail. So person having ordinary skill in the art, uh, if a machine becomes a standard for a human being, then it becomes absolutely a unfair adjudication for that particular person. Vice versa is also correct. A machine invents something. If a person a person having ordinary skill in the art, if it's a human being, then everything or nothing would be obvious, because a human brain might not be able to process very complex algorithms or phenomena. Okay. And vice versa is also true, wherein human beings might be much more thinking in a much more creative or complex way than a machine. So this domain actually becomes absolutely a gray area. So there is no black, no white, but there is no answer as of now. That's the problem. And the last proposition is also very interesting. So you have autonomous machines. They keep on inventing, they keep on inventing, they keep on creating new things, make our lives very easy. What happens if that particular machine infringes on any third party IP? Who should be responsible for such infringement? Because during innovation, during their creation of patents, or doing inventions or practicing new things, the machine may inadvertently infringe on third party IP. So that's another domain which is very, very, very risky, and we do not have any answer as of now. Okay. So next, when it comes to copyright, so copyright is again same thing. So we have authorship and ownership of artistic works. So what happens when a machine writes a story? It might write a story, because as of now, what we see around ourselves, most of the stories are mere combination of known stuff. So you think of this television serials that we see in Bengali and in Hindi. So you would be seeing the same plots running over and over again, and with combinations of such things, thousands and thousands, I would say millions of millions new plots can be generated. Machine can do that. So it can basically read through all existing literature in available to human being over the internet, or maybe in digital format. It can read through all of it, and once it has read through all of it, comprehended it, it can start making logical combinations of such plots to make new plots, to make new stories, to make, I would say, new poems. We do not know that. So who would be the author for such artistic work? Who would be the owner for such things? So those are the questions. Are it's the answer is not there. And the next thing comes as deep fakes. So deep fakes is something very interesting. So as of now today, if we create an image of Rajnikant and do a movie around it through animation, we are infringing on Rajnikant's right. That's absolutely fine under today's law, and Rajnikant can sue that particular person. But think in a scenario wherein that person, Rajnikant, maybe 50 years down the line, he is not there on the earth, and the autonomous machine starts, fakes his voice, fakes his character, and creates movies and sound recordings or something out of that. Machines can do that if they becomes autonomous. Then who would be having the rights? Who would be suing whom? The court cannot, a human court cannot bring in a machine and do adjudication of that. It would be very difficult. So such things, are very burning issues, and they have not yet been solved. The present law does not have solutions for that. So maybe you can also think in this line, what can be done. The last part is present legal system does not have sufficient protection for data. So right now we have data privacy, we have data protection acts, other things, but no specific intellectual property format for protecting data, because data, as we all know, would be the currency for future. So everything, a person who would be having data or a company who would be having data would be owning the world. So Facebook, Google, these companies have huge amount of data with themselves, and they're ruling the world today just because of this data they have. So, there are certain countries in the world which have various sui generis system for data protection or data IP protection on data. Basically, I'm talking about data protection. We all have, but IP protection in data, there are sui generis legal systems which are absolutely inadequate. They are very minuscule in nature and protect and offer very little protection. And once the AI system starts working on data, because the whole success of AI system lies in data, how we manage the data, how the machine processes the data, what are the data models that keep on evolving. There are autonomous machines as of now which can create newer data models, so that it keeps on learning from that and keeps on evolving. So what happens to those, how to protect the IP in those data models, in those data types? So that has not yet been answered. So these are some of the major burning issues on AI and IP protection in today's world. So, all of you can think in these lines. It's very interesting. I also keep on thinking that really, once machine becomes enough creative like us, then, who should be the owner? Can the machine behave like a human being? Can they protect their own IP? Can they be, filing their own patents, license their own patents, generate revenue, have bank accounts, have money over there? Can it happen? Maybe. We don't know that. Okay. So some of the solutions, these are all my personal thought process. So, and some research that I have done in WIPO and other, websites, I have come through some solutions and I have developed on them. Very interesting part is WIPO, that is the nodal body of intellectual property in the world, and established in the WTO, and has direct impact on all of humankind. So WIPO basically has asked each and every country and each and every company stakeholder to provide answer to the previous questions that I have provided. These questions that I brought in, WIPO has posted these questions over there and is asking, answer from all the stakeholders. So it's there in the WIPO website. You can go and search over there. And already 40-45 countries have submitted their response to it. And it's absolutely mixed bag. Some countries support it, some countries say no. So we don't know the way forward. Okay, so for a human creator of an AI system may be designate inventor, author of all inventions, creations, such autonomous AI systems. So, if a human being creates an AI system, okay, then it might, the proposition might be that he becomes, or he is designated as the inventor or the author, and he owns such inventions. Okay, but what happens when such inventions are made without human intervention? So can we really call him the true author? Won't that be a lie to the humanity? Just like the person or the CEO of the company who stated that I know how to develop an AI system. I do not know anything about food storage cans. So how can I be the inventor? Okay, and then think of the question like, what happens when the human dies and his AI system continues its autonomous creation? So the human who has created the AI system, if you designate him as the inventor, tomorrow the person dies and the AI system would not stop, because it does not have any death. It's immortal, so it can keep on creating more inventions, and as and when it keeps on learning and becomes more intelligent, it could do more inventions, create more complex and valuable inventions. So who would be owner of such things? Okay, who can own and assign such creations? So an autonomous AI inventor author may inevitably infringe on third-party IP rights while developing such inventions and artistic works. Who shall be responsible for such infringement? Okay, now the problems from AGI to ASI, once the artificial intelligence level moves from general intelligence to the ASI level, which is the all-pervasive, all-intelligent level, they would be inventing faster and more easier than human beings. They can process millions of terabytes of data in seconds. So if you provide equal protection to AI machine developed IP, then human creativity may be impeded in long term. because human beings, before they can create, machines would be creating faster, and they would be solving more complex problems. So it might happen that human creativity would be impeded, because human beings would start thinking that, well, problems are there, all inventions. So we have this specific term which say that necessity is the mother of invention. So people have a need. To solve that need, they invent. Now if there's a need and the machine starts solving that need, human would not be inventing, machines would be inventing. So that would be another major issue. Okay. So and for data, do we need a specific form of intellectual property for data? Because as of now we don't have it. Okay, so some of the solutions. Okay, so these are some of the solutions I've thought about. So these are all debatable. So you can also debate on this in the question answer session. You can suggest something else. I would be absolutely okay to hear what you guys think. So AI should be named inventor author for autonomously created work. So if a machine creates autonomously, it has to be named as the inventor. Otherwise, we are cheating on the humanity. If a person who knows nothing about food can is named as the inventor of a patent on food cans, that is cheating the humanity. That should not be allowed. So machines has to be made inventors, named inventors. Okay. Whatever a patent or a copyright, any form of IP is developed by a machine, it should have a human assignee. So human should be owner of whatever machine creates, because at the end of the day, machines are for us. We are not for the machines. So it's not like they're another creature or they're another animal in this world. It's not like that. We have created machines for ourselves, for our better life. So we should always be, there should be always a master slave relationship. We should be always the owner of whatever the machine creates. Otherwise, in long term, we may end up in a matrix or a Terminator scenario. Then we should have a governance mechanism, a state-backed governance mechanism for machines which does not have any owner. Okay, the machines which would be omnipresent over internet as bots and other forms of codes and other things, and it would keep on running, maybe in a server or even in serverless computing domain. It might be omnipresent, and it may keep on creating IP, and it may infringe on third-party IP. And hackers and other people or unscrupulous people might create such AI systems which deliberately infringes on third-party IP. So there should be a very strong governance mechanism backed by the governments to ensure such things do not happen. Okay, so next is, for standard of protection or the threshold of protection for intellectual property or patents. So this is a very interesting proposition. So for human beings, we have person having ordinary skill in the art. For machines, we have e-FOSITA or electronic FOSITA. Yeah, so what a e-FOSITA would do, that person having ordinary skill in the art, who is also an electronic one, would think like a machine, and a machine invention would be tested for this particular touchstone. So e-FOSITA would be applicable for all machine-made inventions. So the standards would be higher. It would not be so easy to file a patent by a machine. So standards would be higher, and e-FOSITA would keep on learning, and it would keep on increasing its, I would say, knowledge, so that it's even more difficult to get through the obviousness test by the machines. So AI machines, we can reduce the lifetime, because as I told you, once we move to the ASI levels, AI machines would be inventing very fast. Okay, so if we give protection for 20 years, so that would basically hinder the growth of technology in those days. So reduce, a reduced period of 5 or 10 years might be sufficient for machines or inventions developed by AI machines. Okay, so standard of inventive step or obviousness should be different for human beings and machines. Without that, we do not stand a chance in long term. We may or may not, because we do not know the future as of now. But what it seems, once machines reach that ASI level, they would be solving more complex problems than us in a much easier way and a much shorter time. For data protection, what we believe in IP protection for data, we should have a single comprehensive data IP protection law to cover all data types, frameworks, data models, and everything. So we have to think through what can be the future and develop a law which can basically help us protect the IP in it. And similarly, in tomorrow's world, another very interesting part, machines, as of now, we have it. Machines enter into contracts with machines. So, there are, stock market agents and other investment bankers who have machines executing trades for them, or machines buying and selling shares. So over there, it happens frequently. It happens that one machine sells or triggers a sale, action for a stock, and another machine buys the same stock. Now, there a contract happens between the buyer and the seller. It's always there. So it might happen like the machines would be entering contracts among themselves without any human intervention. So but we have to always ensure that you know. Uh, two machines cannot enter into a contract which basically puts humanity into danger. That cannot be done. So so we have to make changes in the contract. The present contract law might not be sufficient for that. Okay, so I have, till now there was a negativity, I believe, feeling that what happens, machines take over, and if machines keep inventing faster than us, what happens? So let us not think in that way. Machines are our creations, and obviously human beings being more creative, having their brain, would figure out machines, or would figure out systems so that we always keep the machines tamed. And as a master, and if we have a master and slave relation, the machine can be a very strong beast, which would be really a very positive point for humanity. Just in AI and COVID, so this is because of present scenario. I was just saying like how AI is helping human beings in COVID. So it's doing molecular and genetic analysis to find vaccines and cure for COVID. So AI is explicitly and very stringently used across the world in various companies. And then we have AI driven robots and strategy for mass sanitization and community healthcare. So right now we see doctors, nurses, they're facing problems, they're getting infected, they are not allowed entry into their society, housing society. So what we can replace huge amount of such caregivers with AI driven robots in these days, or in this time, with minimum human intervention, and robots do not cannot be affected by COVID. So that's a very strong point for them. So it can also be used for prediction of spread and effective lockdown period, geofencing systems. So it can do all statistical and mathematical modeling in a jiffy, in a very easy way, and help us. So a running existing business with minimal human intervention. So that can be another positive point if we can use AI very strongly. So right now, as we see, all of this is done by ANI, the first step. Okay, it's not even AGI, and just forget about ASI. So right now, ANI is helping us in doing all of these things. Just think if we had ASI at this point of time, probably it could have invented a vaccine or a cure for COVID in one day. All the trials and everything, human trials could have been simulated by it in 5 or 6 days, and within 7 or 8 days we would be having a cure ready. And a AI driven plant or a manufacturing center could have done mass manufacture of such drugs, and by this time there would have been no COVID at all. So there's a huge potential for AI. It's just like a gun. So you have a gun, you can use it for killing a human being, you can use for doing some good things. So it's just a tool. So we have to have very specific laws, we have to have very specific human provisions and human policies to ensure that AI evolution happens in the correct direction and it benefits mankind. Because in advanced form of AI, it can help us in every field of life that we are in. So AI is all purpose. So these are my resources. So that's it for for now. So I believe I could provide you some food for thought. Think in these lines, and this is something very interesting, very intriguing. So that's it. I'm now opening up the session for questions. So please give thrust the questions to me from session 1, session 2, session 3, and session 4. Any questions you have, please you can ask me.
Okay. Thank you, sir. Now we can put down your slide. Yeah. So I request everyone to raise your hand one by one. You may ask questions to him. So first, I will invite Mr. Rahman, Asikur Rahman. Yeah, please go ahead.
Hi, good morning, everyone. I have a question. You have told that open source component leads to an technology-driven software to an open source. How do I know that if I use an open source software from somewhere, that leads my software to be open sourced?
Okay. So very broadly speaking, so there are three types of mainly open source software. So there are certain license, and this is driven by the license types they are they're coming with. So each and every open source component or software is released under specific license type. So one type of license is permissive. So permissive license like MIT and Apache and other similar types of licenses basically allows you to use your code or your proprietary code seamlessly with such open source components without much implication. And then on the other side, we have the strong copyleft licenses like GPL, LGPL, GPL 2.0, LGPL 2.0, and similar kind of licenses. So basically, if you use those licenses, it comes various types of restrictions. It says that if you are using this, some linking concept, some have dynamic linking concept, where if you use your proprietary code along with those particular types of open source licenses, it might end up into contaminating your code, and then you would be forced to release your code under open source. So how to understand which to use and not to use? It's not an easy ball game. It's a very difficult ball game, because you have to understand the type of license that you are using for that particular open source that you are using. So again, for this I would request that you always contact a IP attorney. But as a thumb rule, you can always know that unless you are doing commercial usage, you are fine. The moment you are doing commercial usage, it's better not to use the copyleft licenses. Okay, so this is I would say this is a very blanket statement. This is not true always. There are means of bypassing the copyleft issues or the copyleft or the restricted license or restrictive license. There are ways of doing it, but it would take a different session altogether how to do that. But as a thumb rule, you can always believe that usage of restrictive licensing is risky.
Okay, thank you.
Okay. Now I request Mr. Arup.
Hello.
Yeah, please.
I am Arup Chaudhary. Acha, my question is the new the new design methodologies or mathematical modeling. This type of new innovation, this will fall under which category of patent or copyright? New design methodologies of a building, of a structure. I am a civil engineer.
Okay, got it. So see, specifically talking, there is a specific type of intellectual property design registration, we call it. We also call it industrial designs. Industrial design basically protects the look and feel of articles of manufacture. So what can be articles of manufacture? It can be a mobile phone, it can be a pen, it can be a cup, it can be a building, anything. So if you are doing a specific design to make the building look very good and different, then that aspect is protected by design. But now think, you have designed the building in a way wherein it becomes resistive to earthquakes, or it offers very less wind resistance. Okay, so you have made some structural changes in the building. Now that is basically, you are trying to solve a problem, correct? Over there, there's a problem. Problem is enhanced earthquake resistance. So the moment there's a problem and you have tried to solving using a technological means, that should be protected by a patent. So these buildings, the aesthetics, the outer look and feel can be protected by designs, and the functionality of such structural changes that you make can be protected by patents.
Okay, thank you. Any more questions? Okay, so we will conclude today. Oh, sorry, one more person has asked the questions. Mr. Dash, Shankar Sharup Das.
Sir, I have a small question. Is it audible?
Yeah, please go ahead.
Yeah, please.
Sir, as you told that machines can also be considered, though the rule is not there for patent, for ownership like patent or copyright. But sir, again you told that machine is for man. Then why to give importance to? Because machine is already developed by man, though it is artificial intelligence, whatever maybe. But machine is developing. So though the person who is developing something and is not having some idea about that particular thing, he is getting the full patent. So in that case, why to again consider about the machine?
Okay, so now let's think for a scenario. Like suppose I am an inventor. Okay, so I, as a human being, I invent say new software. So the moment I file more patents, that basically that increases my employability. So today I am working in Cognizant for 100 rupees. Tomorrow another company may come and say that I would give you 130 rupees because you are a very good innovator. Similarly for machines, if we can mention machines as inventors, then what happens is tomorrow more and more people or more and more organizations can come down and buy such machines. So like suppose I have invented a machine. The machine is autonomously working and developing new inventions, but the machine has a potential to invent in various other fields also. So if I can mention the name of that machine as the inventor, then I have an advantage. First, tomorrow I can sell that machine to a different company saying that, see, this is a very innovative machine. Second is I can keep on inventing more such machines. So I am inventing machines. Machines are inventing newer inventions. So if we can create two layers, that would make more economic significance for me, because I am an AI inventor. So I invent AI, and AI invents some other technologies. So these are two layers of economic significance, and two layers of licensing also can happen over there. That is first. Second is that if you look into the jurisprudence of intellectual property law, it is always stress on the true and first inventor. The humanity should know that who is the real inventor. So over there, the moment we do not name the machine, we name that human being who has developed that machine as the inventor. Then just that person, that CEO stated, I know nothing about food technology. Then the problem is, people are in the food technology department or would understand that that person, the CEO, is the inventor, and believe him that he is a pioneer in the food technology department. So it's basically falsifying data to the public at large. Public should know that no, the real inventor is the machine. The machine is a pioneer in the food technology department, not the person who has invented the machine. So it's all about public clarity and giving the correct knowledge to the public. It's all about all forms of IP is emanating knowledge freely to the public and true knowledge to the public. So we cannot falsify data.
Okay. Thank you, sir. Thank you.
Okay, thank you. Thank you very much. One more question. Mr. Arup Shah Chaudhary. Please go ahead.
Hello, I am Arup again. Acha, who is the patent or copyright giving authority? The Government of India Patent Office or any Government of India office of that particular field?
No. So it's we have a specific Government of India organization which is called IPO, the Indian Patent Office. Similarly, for copyright and for trademarks, we have specific organizations, which is directly under central government. So all forms of IP protection are given only by that department. So it's not like I have invented something in civil engineering department. So a government organization relating to civil engineering give me a patent. The answer is no.
Achha.
It would be given by IPO. So any patent in India would be issued by Indian Patent Office.
Okay, thank you very much. So we'll end up today this session. Tomorrow again at 11 o'clock, there will be another session that is on the intellectual property in the academia, which is more relevant to all of you. So I hope you're going to join. Over to Archita.
Thank you so much, Mr. Banerjee, for this wonderful presentation. Once again, you mesmerized our participants. I'm very sorry my video is not working right now due to network issues. I just want to go for a quick summary of whatever we have learned in all the 4 days. I think participants who have missed some portions of this lecture, they can go for this one. They can just go for a recapitulation of whatever we have done till date. So in the first session, which is taken by Dr. Pinaki Ghosh, over there we have got the introductory concepts of IPR, process of filing IPR, transition in the process of IPR, where and when a person can apply for IPR. So these are the basic learnings. These are the basic learnings from session 1. Moving to session 2, I mean day 2, where we have started with Mr. Banerjee, and for the next 3 days, Mr. Banerjee is with us right now. We had patent, basic concepts of patent, who can file it, which works will come under patent, what is the prior art and its linkage with patent. So these were the learnings from session 2, I mean day 2. Now moving to the day 3, it was an exhaustive discussion on the anatomy of a patent, where more emphasis was given on the concept of claim, which was considered the most important part of this anatomy of patent, and where we have definitely gone for the concepts of technical and non-technical aspects of a patent, of a claim. Then we had concepts related to patent infringement. Then we have gone for the very basic concept where Mr. Banerjee is actually working right now. In case of software industries, what IP practices they are used to do, how it is used to be done, and which is very much relevant and up to date. And definitely, as Mr. Banerjee was saying, it might be a sort of similarity might happen in other cases when you are actually planning to go for these forms of practices. And lastly, we had advantage of having a patent portfolio. And in that case, what are the positive sides of this, having a patent portfolio? At the end, it was extremely informative when Mr. Banerjee shared some case studies which actually clarified almost all our doubts. That's why in the day 3, we had a lesser number of questions. If I can relate, it was 2 or 3 participants. I only asked you to ask questions to the panelists. So case studies were much more informative, and very much great thanks to Mr. Banerjee for sharing these case studies to make the concepts or to make our understanding much more clear and better. Now, one more thing I forgot to mention over there. In the last class also, we had a conversation on do's and don'ts related to the patent. What should we do and what shouldn't we do when we are thinking about patents. Now, moving to today's session, when we had Sarah's talked about IP protection and AI. Now, this being this is being a burning issue, and then people who are from the more precisely from the engineering background, they might relate both the things together in a very better way in comparison to others. But what we have seen, the how this AI evolution actually happened, and what will happen in case of AI patent proliferation. Issues related to the issues actually that evolved in the present IP regime that actually related to patent, copyrights, and data, and due to the presence of this AI. And lastly, Mr. Banerjee has shared certain solution to the problems that actually cropped up due to this advancement in technology. And I'm sure that these solutions actually have made our concepts much more clear and understandable. Thank you once again, Mr. Banerjee, for having with us for all these 3 days. We will have Mr. Ghosh with us for all the 7 days, but definitely as and when required, we know that Mr. Banerjee will be available with us. Okay, thank you so much once again. Thanks to all the participants for joining with us. I'm sure you had a wonderful session till day 4. Next day we will have one more new panelist. We will have with a new more topic. So till then, see you at tomorrow at 11 a.m. Thank you so much for joining with us. Thank you.
Thank you.
Thank you, Professor Banerjee.
Thank you. Thank you to all.